Step-by-step procedure in filing a divorce petition in Nigeria. Kindly know that in this context, the parties shall be called petitioner and respondent. The petitioner is the one filing the divorce petition, while the respondent is the one whom the petition is being served against. In another circumstance, we might have a co-respondent. In the circumstance where the petitioner is alleging adultery, the person in whom the adultery is being alleged against shall be added to the petition and that shall be called the co-respondent. My name is Samuel Oladele. So the first thing to note is the drafting of the divorce petition. Divorce petition can be drafted by either the petitioner himself or by engaging the service of a legal practitioner. So if the petitioner engages the service of a legal practitioner, the legal practitioner, after drafting the divorce petition, shall send to the petitioner to cross-check or to proofread if there's any other fact missing or so. So after the drafting, the petitioner shall ensure that he signed the verifying affidavit attached to the petition before filing. So having signed the verifying affidavit, the divorce petition shall be filed in the High Court. So the divorce petition, which is under the matrimonial proceeding, has just one jurisdiction in Nigeria. So it can be filed in any of the high courts in Nigeria. So the next thing is assignment of the divorce petition to a judge. That's after filing. The divorce petition will be assigned to a judge from the court registry. So after the assignment of the divorce petition to a judge, the next step is to obtain dates from the court. That's to hear the case or to mention the case. So after obtaining the dates, you make sure that the divorce petition is being served on the respondent. So the divorce petition shall be served personally on the respondent by the bailiff of the honorable court in which the divorce petition is being heard. So in the circumstance where the bailiff of the honorable court finds it practically impossible to serve the respondent personally, he will depose to an affidavit of non-service, and the legal practitioner handling the matter shall file an application for substituted means in order to serve the respondent. So the process shall be filed via ex parte, shall be moved in court, and if court deem it fit to grant sale, it shall be granted. So the mode in which the order prayed shall permit the petitioner to serve the respondent. So the next step is upon notifying the respondent of the petition in court, the respondent can choose to either respond or not. So if the respondent chooses to respond, the respondent can either respond personally or respond through a legal practitioner. Once the respondent chooses to respond, the respondent is entitled to file an answer, and or if the respondent is against the petition, file a cross petition against the already filed petition, the divorce petition in court. Upon the filing of the answer and cross petition by the respondent, the petitioner is entitled to file a reply to the answer and answer to the cross petition of the respondent. So having done all of this, pleading is deemed to have closed. So the next step to be done is to conduct a compulsory conference. However, compulsory conference is only mandated where there are children in the marriage or there is a joint property in the marriage. So this is the meeting where the property will be discussed, or the children affairs will be discussed. That is, the maintenance of the children, the education of the children, the custody of the children, and the general welfare of the children. Having conducted the compulsory conference, the report of the compulsory conference shall be drafted and shall be signed by all the parties together with the legal practitioners, and shall be filed in the court where the divorce petition is being held. Having filed the report of compulsory conference, the next thing to be filed is the necessary statutory form to set the matter down for either defended hearing or undefended hearing. It shall be defended if the respondent has interest or has responded to to the petition filed by the petitioner. It is undefended if, having served the respondent with the necessary forms or necessary documents, necessary notice of petition, and the respondent fails to respond. So that is undefended. So having done this, the matter shall be set down for trial. So there's a circumstance which arises where the petitioner or the respondent is not available to testify in court physically. In this circumstance, either of the parties are allowed to testify via virtual hearing, that is virtually through Zoom or any other electronic means. But this is not automatic. There shall be an application that will be made to court, because you have to seek the leave of the court to testify virtually. So the legal practitioner of either of the parties shall file an application before the Honorable Court to set down the matter for virtual hearing. That is where either of the parties cannot testify physically in court. And the application for virtual hearing shall be supported by enough evidence to prove that truly either of the parties cannot physically come to court, and shall state the exact location where the party bringing the application resides or is being resides currently. So having granted the party or either of the party coming through virtual or through physical to testify, the court shall adjourn the matter for hearing. That is the day the parties shall come to testify in court. So after that, the parties shall come to court to testify. After the trial, the court shall adjourn for parties to adopt their final written address. The final written address is just the legal agreement of both parties. So counsel or parties shall adopt their final written address, where the judge shall thereafter adjourn for judgment. So the judgment shall be granted. The judgment shall include a decree nisi, where the case is successful. That's where the case is successful, and shall become absolute after 3 months, where no one challenges the judgment. Thank you.